I'm Ben Meiselas, joined by Harry Litman. Harry, the United States Supreme Court now has essentially the full briefing on Donald Trump's claim of the presidential immunity as it relates to an application for a stay of the DC Circuit's ruling. A super brief history. Of course, the district court back in December denied Donald Trump's motion to dismiss the indictment where Trump asserted absolute presidential immunity. He appealed it to the DC Circuit Court of Appeals. They made their ruling last week, or 10 days, 12 days ago or so at this point. They gave Donald Trump until February 12th to file an application for a stay pending petition for certiorari. On February 12th, Donald Trump brought that right to the United States Supreme Court, asking for a stay. It requires 5 justices to do that. United States Supreme Court, please stay. Please continue to pause everything. Special counsel Jack Smith then responded within 48 hours, even though Justice Roberts gave Jack Smith until February 20th to file his response. And special counsel Jack Smith says, you don't need to stay this anymore. Hey, Supreme Court, remember when I went to you back in December on an expedited basis, you rejected me? You don't want to hear this, do you? Just send it back. But if you do want to hear it, why don't you convert the application for a stay into a grant of certiorari? Then we expedite oral argument. Donald Trump's lawyer then filed a response. I'm not even sure if a response was invited to the response. Nonetheless, they filed their reply saying, this seems disingenuous. Special counsel Jack Smith previously went on an expedited basis to you saying you should hear it. And now special counsel Jack Smith saying, don't hear it. To that, I've said in prior videos, Harry, there's 2 data points that are different than when special counsel Jack Smith made the request back in December. One, the Supreme Court rejected Jack Smith in December, which Jack Smith pointed out. You don't want to hear this, do you? Also, the DC Circuit Court of Appeals has ruled, also rejecting Donald Trump's claim of absolute presidential immunity. And Jack Smith says, look, Trump has no prospect of success. Look at the DC ruling that just came out now. That's intervening data. So whoosh, a lot of data right there. I want to get your perspective, but I wanted to catch everybody up on the status of this. What do you think the Supreme Court's going to do, Harry?
Okay. And by the way, when will they do it? You're right. They meet, their conferences are on Friday, around 3:00. They conferred today. It's not out of the question. They usually say what their orders are on the following Monday, but they had all the briefing there. And the really important thing to underscore, and you did, Ben, but I want to expand on it, is that it is a motion for a stay, which he needs to get. So that's 5 votes rather than 4, but that's not even what's important. What's important is to get a stay, you have to make a certain showing, and that showing is a number of things plus probability of reversal on the merits. And everyone from way back, and including you and me, have been asserting the court is not going to go for Trump, and the real play has been about delay, etc. But if you're a justice and you look at it honestly, or even you're a justice and you're looking for a way out after taking on Colorado and not wanting to, own the actual delays in the trial any longer, I'm sorry, he just cannot satisfy the likely to prevail standard. And his reply, which you're right, you don't technically get one, but they'll take it if they give it. He just first comes out of the box with like a screed that, like as if some impoverished defendant might make, really had no law in it, and just basically saying Smith is trying to, be selective prosecution. But when he gets the argument why he should prevail, it's the same old tired stuff that the DC Circuit really made very clean, meticulous work of. The Marbury, you've gone over it for your viewers, but Marbury versus Madison idea and the crazy ass, impeachment judgment clause idea, and his same arguments. And really the down the middle right answer here is to deny the stay, because he's not likely to prevail. And if that happens that very day, the whole frolic and detour about immunity is over. And that's the only big one that he had to do. So we're back to Judge Chutkin's courtroom, and maybe looking at something, say, in May. Now, and if it doesn't, I think we're a couple months down the line. But I got to say, I'm not, I'm not shy about making predictions, including being wrong. And I actually did say on MSNBC, if you put a gun to my head, I would say X. And the X was that they deny the stay. But this is, I think, exquisite. The more I think about it, it just seems exquisitely balanced on the could go. If they do grant the stay, I think they will take, just as you said, his request for a stay as a motion for cert, make it very quick, hear the case probably in, maybe late March. Maybe we get an opinion in April. They know they have to be speedy, but that's a couple months more than just delaying it. And, for viewer fun, so you can score, keep score at home, I'll say that it's that they grant the stay, but they're the Supreme Court. This is a big case. You really would expect them to say, this is for us to decide. So what I really want to say for your viewers to understand is I see this one, and people I respect, I think, see this one as like, whoa, just 50-50 down the middle, which way they go.
Okay. Which way are you going? Just so I can have you. Are they going to grant the stay or not?
Here's the gun to my head. I am denying the motion for a stay. I'm saying, and if they do that, that'll be in a week. And or we'll know. And returning it to Chutkin. Happy days are here again. That whole frolic and detour is over. There you go. You got me on the record.
We're also for responsible invisible gun ownership here on the MeidasTouch.
Absolutely right.
So we just put the invisible microphone we put the invisible microphone to your mouth. That's about it. I don't know what our rivals at MSNBC do, but sounds a lot more violent than what we do. I'm just saying.
Okay.
But Harry, I want to talk about something though, to be truthfully fair and balanced here in the coverage. There is something to be said, though, about the special counsel Jack Smith did go to the Supreme Court in December, and he did say to them, this is a monumental issue that you need to resolve before the D.C. Circuit resolves it. It's so fundamental, you need to hear it. The Supreme Court rejected that. Then the D.C. Circuit made its ruling and then gave Trump the deadline to file the application for a stay. Do you think Special Counsel Jack Smith adequately addressed that issue? Trump's lawyers clearly jumped right on that in the reply. Do you think Special Counsel Jack Smith addressed the issue with, you rejected it, Supreme Court, and now we've got this ruling by the D.C. Circuit. This is not an issue. You now have their record. Their record makes it clear that there is no prospect of success on the merits. You now have to apply that standard and reject the stay.
This is fun, because if I understand your position, we got a clean disagreement, you and me, Ben, because 100% they now have, this is not a little incidental detail. You have the second most prestigious court in the country in a bipartisan fashion with a very careful, thorough, methodical, Lucite box of an opinion. And now the question is, now that they've held it, remember, he could be moving for cert, and then you could say, well, it's totally right, but it's good for the Supreme Court to decide. That's not the motion. It's freeze this thing below because I'm likely to prevail, etc. And the fact of that DC Circuit opinion is a game changer, and I see no logical inconsistency with Smith saying before, we need this and need it quick, so jump the gun. But okay, you didn't, and now the DC Circuit came in and did it beautifully. There's really not a comma to change. Absolutely, I think thorough, consistent, logical to say at this point, don't grant a stay.
By the way, for no confusion, and I know perhaps my visible gun analogy, but to be fair, I do agree with you. I just wanted to get, I want to try to. I want to try to probe these data points
Yeah.
and try to understand it. Do you think Trump's lawyers,
Rats. I thought we had a real disagreement. Oh, well. Next time for
do
sure.
you think Trump's lawyers made a mistake in not seeking the petition for certiorari with the application for stay, making it clear that really what they're after is just delay, and that they're going to flirt with en banc review before the full DC panel, and that kind of overplayed their hand and they should have sought cert versus just an application for a stay?
And they actually said, "Can give us a long delay so I can go back to the DC circuit and try to go." The short answer is no, and here's why. It's a huge case, a huge issue, and the Supreme Court is going to decide basically without regard to the arguments of Smith or Trump. They're either in there saying, this is for us, we got to do it, or they're saying good reasons not to. But the advocacy, so often flawed, I think is really beside the point.
Well, let me ask you this final question then, and I will connect this to what's happening in the Southern District of Florida, where Judge Eileen Cannon made this ruling denying Donald Trump's attempt to try to adjourn certain pretrial deadlines. There's a hearing that happens March 1st. That's like a status conference with this May 20th, 2024 trial date. And some people may be saying, wait a minute, did Judge Eileen Cannon actually reject something that Donald Trump requested? Where my mind went right away is she may be trying to protect that May and June time period, knowing that the Supreme Court may send this back to Judge Tanya Chutkan, who may be trying to fill it in for May 2024. Am I completely overthinking that? Is there something to that?
I don't think you're overthinking it. But I think the thing to keep in mind there, she's already moved the date. The date is now just on paper, and it's fiction because she's given 3 months of delay, and she's now this week, including embarking on this sort of long trip upriver about the Classified Information Protection Act. I think perhaps kind of cunningly, she didn't change the date because that could be an order that could actually be appealed, and there next time she makes a blunder, and there is one that's going to be served up on the 23rd, or Trump has to respond. She made a big mistake in ordering the publication of certain discovery, but it's already a bogus date. It's all she has. She's given 3 months of extensions on other stuff. So there's other things one has to do pre-trial, and she just it's all over but the shouting for that date. So
if Judge Tanya
that's not what I think she did.
So if Judge Tanya Chutkan gets the case back, even if she still sees this May 2024 deadline, Judge Chutkan may say, well, I'm going to make mine May 19th. And if they both go, they both go. But I look at your date as a fake date because I don't think that's like Judge Chutkan's not going to treat the Judge Cannon date as a real date.
And she may do something else. She may actually pick up the phone and call her. We know that Justice Merchant in New York did exactly that with Chutkan when he said, we're sticking with March 25th for this first date. Judges can talk to each other and they can, is it real? Is it not? And he knows that space, even whatever is nominally on a docket, is free and clear. And Chutkan will know that the prospect of a trial in Mar-a-Lago, which should have happened, cut and dried case, but Judge Eileen Cannon, it ain't happening. She'll know that, and if she's not, she'll give her a collegial call and confirm it.
Everybody make sure you subscribe to the Talking Feds YouTube channel. They're on their way to 250,000 subscribers. Help them get there. They're partnered with the MeidasTouch network. It's a growing channel. I love the analysis there. So if you can, make sure you subscribe. Let's see how quick we can at least get to 200,000. In any event, make sure you're subscribed to our channel. Check out the Talking Feds podcast as well. And thank you all so much for watching. And Harry, always a pleasure.
Always a pleasure. Thanks, everyone. And thanks, Ben, in particular. You're really helping us grow, and it's fun working with you.
You too. Have a good day, everybody.
Hey Midas Mighty, love this report? Continue the conversation by following us on Instagram at MeidasTouch to keep up with the most important news of the day. What are you waiting for? Follow us now.